Okay, I'll let people in.
Thank you. Good afternoon, everyone, and welcome to docket number 240822, the petition of Alco Finance Limited alleging violations of Connecticut General Statute Section 16243A by the United Illuminating Company. My name is Marissa Gillette. I'm the chair here, and I'm joined virtually today by my colleagues, Commissioners Michael Karen and David Arconti. We are here this afternoon for oral arguments in this matter, so I will begin by taking appearances, please. And I see Attorney Malone.
Good afternoon, Chair Gillette and Commissioners Arconti and Karen. Tom Malone for the petitioner, Alco Finance Limited.
Thank you. And can I take appearances for the company, please?
Good afternoon, Chair, and Commissioners Harris and Robbins-Pesci for UI.
Good afternoon. Are there any other parties wishing to enter an appearance at this time? If not, we will begin oral arguments. We'll turn first to Attorney Malone. In keeping with our practice for oral arguments, we'll do one round followed by a brief round of rebuttal, and then I will invite my colleagues to interject questions at their discretion. So we'll turn first to Attorney Malone, please.
Thank you, Madam Chair. Okay, so what this case is about, it's pretty clear from the proposed decision, is PURPA, and in Connecticut, PURPA is implemented under Connecticut General Statute 16-243A. So the specific provision under Connecticut law that's at issue here is subsection D, which requires a utility to negotiate in good faith to arrive at a contract which fairly reflects the avoided costs over the life of the contract. And that provision also says that the life of the contract at the option of the generator, here the petitioner, can be up to 30 years. Now, on the other hand, United Illuminating filed a tariff pursuant to a docket that PURA conducted after our challenges at FERC that limits the term of the contract to 7 years. So there's a direct conflict between the statute, which says up to 30, and 7, which is what United Illuminating offered or said they would do. So we offered two proposals. One was for energy only over a period of 20 years, because that's a typical PPA in Connecticut. A rate that was as low as 5.1 cents per year per kilowatt hour and as high as 9.4 cents. And that was based off a study that, or an avoided cost study that was conducted on behalf of the state of Connecticut, state of Massachusetts, and United Illuminating, among others. Then the second offer we made was to accept the energy-only rate that's in that 7-year tariff, which was 5.3 cents per kilowatt hour for the first 15 years of the contract, and for the last 5, because we need 20 years to finance a project, at the rate that is the cap for the NRES program, which is 145.97 cents per megawatt hour. And for the last 5 years, we would deliver the RECs too. And as we all know, in general, projects in United Illuminating territory, either if it's under the NRES or the SCEF, they're usually at the cap because it's so expensive to build there. It's hard to get projects there. So we thought we made good faith offers that were based on current rates that United Illuminating enters into separately under other programs. United Illuminating just took the position that they only had to offer 7 years. And the proposed decision says that offering only 7 years is somehow negotiating in good faith a longer contract that's required by Connecticut statute. So in our exceptions to the proposed decision, we also noted that the Vermont District Court, because we continue our PURPA challenges in various parts of the country. The Federal District Court in Vermont held that locational marginal price, which is what the United Illuminating tariff is based on, is not a reflection of avoided costs under PURPA for long-term avoided costs. It is, of course, for as available electricity. And that's what the FERC says too. And the other problem with, of course, that we mentioned in the exceptions is that the tariff uses a retrospective LMP. It's not even by any means a forecast. And the law, at least in my view, clearly requires a forecast. And I attached the Second Circuit brief that we filed in Vermont because, just so that all the issues are explained in case anybody's interested, including the one that relates to what I would call the single plant rule, which is Connecticut embodied in a parcel aggregation rule. So PURA has never ruled that the only PURPA contract is the 7-year contract under the tariff. But if they issue this proposed decision, then that's effectively what they're doing. PURA is adopting the 7-year rate and saying there's nothing else that we're going to provide or that you can negotiate with utility other than that, even though Connecticut statute says differently. And as far as the LMP is concerned, that whole tariff, at least one court now, says differently. And I think likely the Second Circuit will at least agree with that position too. That's all I have. If you have any questions, I'd be happy to respond.
Thank you, Attorney Malone. Not seeing any questions from my colleagues. Commissioner Karen?
Yeah, no questions, Madam Chair. Sorry.
Okay. All right. Thank you. I don't have any questions myself, Attorney Malone. So let's see if Attorney Robbins-Pesce has any first round comments here.
Thank you, Madam Chair. I think we here have a clear difference of interpretation of 16243. From the company's perspective, the reading gives PURA the authority to set the rates and conditions for private power producers, which is what I believe ALCO would be in this instance. I don't think there's any debate there. Regarding the 30-year term, we've heard this before. The company's position and interpretation is that it is a may and not a shall. It would seem to be that if the statute was prescribing that the producer has complete domain and authority to set the length of the contract term, that's not much of a negotiation, especially since that would also seem to conflict with the fact that PURA, again, has the authority to set the terms and conditions regarding energy and capacity sales. Our interpretation of the 30 years is that it's saying it could be up to if the producer so is open to it, but it's not saying that they have the right to it. It's just saying it's putting a cap, is what I'm trying to say here, on the length of the contract. It's not setting a requirement or giving the producer some sort of separate authority or option. And briefly, the case in the Second Circuit in Vermont's been discussed. Have a distinct difference in interpretation of that ruling. Did not see anywhere in that ruling that it says LMPs are specifically prohibited or invalid. I believe the position that it's silent on it, as it wasn't valid or germane in that particular instance, and I'm not aware of any authority from FERC stating that LMPs are not valid. I believe, again, they've been silent on that issue. They've made a more definitive ruling. I believe it's in FERC Order 872 regarding as-is facilities, but I don't think on more contractual LEO-based instances they've had any type of definitive ruling anywhere that I'm aware of. So with that being said, I believe that the authority issued a prudent and wise proposed decision, and would respectfully say that it should be a final decision should be issued in the same language.
Thank you. Do my colleagues have any questions? All right, seeing none. Attorney Malone, as promised, will do a round of rebuttal.
Thank you, Madam Chair. I didn't cite it in our exceptions because this is the first time I'm hearing the issue from United Illuminating about that it may extend to 30 years. Pretty sure there's precedent from around the time when this statute was passed, issued by PURA, that states that the option is up to 30 years at the option of the generator. I mean, but and FERC Order 872 said that LMP is only acceptable for as available. And that's what we cited to the Vermont District Court when they were reviewing whether Vermont's quote alternative tariff would qualify under PURPA to try to get out of the box that the Ninth Circuit put the CPUC in the Winding Creek case. But it just seems to me that given the rates that we offered, I mean, if UI or PURA wants to stand on the 7-year term, I mean, it's fine. There's nothing I can do about that except, appeal and file, a case in federal district court, which, I don't want to do, but it's just a lot of effort for, given the rates that we proposed, which are rates that UI is going to pay under programs anyway. And in fact, most of the times UI's programs are undersubscribed. But in any event, I just don't think that the statute can reasonably read to say that UI has to consent to an election by the generator to go up to 30 years. And if it helps, I'd be happy to look back at that precedent because I think I've cited it in probably in the original PURPA docket that started in 2016 before PURA. I have no other comments.
Thank you. My colleagues have any questions at this time? Oh, great. Thank you. Attorney Robbins-Pesch, any rebuttal?
No, nothing further, just that the tariff terms, again, are still available as approved by the authority in 23-12-20 to Mr. Malone and Alco.
Okay. All right. Thank you, gentlemen. I appreciate your efficient use of our time this afternoon. Appreciate you presenting the arguments for our consideration. At this time, I will advise you that the commissioners are going to take under advisement both the oral arguments and the written exceptions that have been filed. I think this matter is currently slated for a vote on March 26th. If that date is to change, we will make any updates to the external calendar for docket 240822. With that being said, unless there are any administrative matters, I believe we can adjourn and return everyone to their afternoons. Thank you very much for participating in the oral arguments today.
Thank you, Madam Chair and Commissioners.